India Legal presents Courts Roundup.
Hello, I'm Hishe and you're watching Courts Roundup. In this program, we bring you the latest legal news, biggest and most significant hearings and judgments of the day. We also bring you the details of court proceedings. Before we begin, here's the headlines. The Supreme Court issues notice in a petition filed by Facebook India head Ajit Mohan challenging the Delhi government's peace and committee summons to him in relation to Delhi riot. Delhi High Court issues notices in Sanjay Singal challenge to IBC provision on insolvency proceedings against personal guarantor. The Delhi High Court has set aside the summons issued against Executive Director of PNB, Dr. Rajesh Kumar Yaduvanshi, for alleged fraud committed by Bhushan Steel Limited. Rajasthan High Court states CBI Court's order for issuance of arrest warrant against Arun Shourie wraps courts over arrest warrant.
India Legal presents Courts Roundup.
Facebook India Vice President Ajit Mohan has moved the Supreme Court challenging the summons issued by the Delhi Assembly's Peace and Harmony Committee, which is looking into Facebook's alleged failure to track down hate speech. Mohan has stated that this issue falls within the exclusive domain of the Union of India. The Supreme Court has issued notice in a petition filed by Facebook India head Ajit Mohan challenging the Delhi government's peace and committee's summons to him in relation to the Delhi riots. A bench of Justice Sanjay Singal, Aniruddha Bose and Krishna Murari also ordered the committee not to hold a meeting with respect to the issue till further orders. The Assembly panel on Peace and Harmony is looking into complaints on the role of complicity of Facebook officials in the Delhi riots that took place in February this year. Mohan was issued two summonses on August 31st and the second on September 18 this year. The petitioner has clarified that although he does not seek judicial review of a state legislature's right to merely discuss issues outside of its legislative competence, so long as it does not seek to exercise power over non-members. However, when an inquiry into a subject matter over which the legislature lacks jurisdiction extends beyond its members, whether by summoning non-members at the threat of sanctions for refusing to appear or by directing agencies to take action against those non-members, the matter is amenable to judicial review. Petitioners submit that those precise circumstances are present here and require this honorable court intervention. It is averred that the committee improperly seeks to exercise its power and privileges in a manner that exceeds the constitutional limits of the Legislative Assembly. Mohan stated that the committee has summoned him and threatened to hold him in breach of the committee's privileges if he does not appear and give testimony. In this context, he submits that there is no law that empowers the state legislatures, including a committee formed by that legislature, to take coercive action against any person unless it obstructs or impedes its legislative functions. The Delhi High Court has issued notice in petition by ex-chairman of Bhushan Power and Steel Limited, Sanjay Singal, challenging the provision on personal insolvency proceeding against personal guarantor under the Insolvency and Bankruptcy Code 2016. Singal has sought the striking down of Section 95, 96, 97, 99, 100 and 101 of IBC insofar as they apply to personal guarantors of corporate debtors, and the consequent rules notice to the Central Government Insolvency and Bankruptcy Board of India and State Bank of India was issued by a division bench of Justices D.N. Patel and Justice Pratik Jalan. The court, however, refused to pass any order of stay in respect to SBI's notice to Singal under the impunged provision. Notwithstanding the pendency of the corporate insolvency resolution process of Bhushan Power and Steel, SBI has initiated a recovery proceeding before the Debt Recovery Tribunal against Singal in relation to several guarantees. In the meantime, the central government notified the provision on personal insolvency against personal guarantors to corporate debtors, and a notice was issued by SBI to Singal under them. Singal has pleaded that the enforcement of sections in relation to personal guarantors to corporate debtors was wholly impermissible in law, as it was an unconstitutional usurpation of legislative power by the executive. The Delhi High Court has set aside the summons issued by the ASJ against the Executive Director of the Punjab National Bank, Dr. Rajesh Kumar Yaduvanshi, for alleged fraud committed by Bhushan Steel Limited. A single-judge bench of Justice Vivu Bakru noted in his judgment that the impunged summons issued to this petitioner and the impunged order, the limited extent that it directs the issuance of summons to the petitioner, are set aside. The petition has also been filed by the Executive Director of PNB, Dr. Rajesh, challenging the order of the ASJ directing issuance of summons to him in the case of the Serious Fraud Investigation Office versus Bhushan Steel Limited and others. The summons has been issued on the ground that there was sufficient material placed on record against the petitioner for him to face prosecution in respect of offences under Section 128, 129, 448, read with Section 447 of the Companies Act 2013. The main issue in this matter is that whether the petitioner can be prosecuted for the alleged fraud committed by BSL and or promoters solely for the reason that the petitioner was a director of BSL, and whether there is any material on record to indicate that the petitioner was complicit in the commission of the alleged offence. The bench noted this suffice it to state that the gravamen of SFIO's allegation is that the promoters had borrowed funds in companies from various lenders, including PNB and SBI, and had, through an elaborate scheme, siphoned of the said funds through other companies for their gains. Delhi High Court had reserved order in application moved by Enforcement Directorate and Central Bureau of Investigation seeking early hearing in 2G spectrum appeals. The single bench of Justice Rajesh Sethi reserved the order after giving patient hearing to all the parties over the course of 2 working days. Earlier, the court had allowed the Enforcement Directorate to move an application for seeking urgent hearing on leave to appeal filed against the acquittal of Araja and others in the 2G spectrum case. Appearing for the ED, ASG Sanjay Jain had informed the court that he had already concluded his argument on leave to appeal in the CBI matter, and even the respondent had started making their submission before the normal proceeding of the court were suspended due to the lockdown. The counsel for the respondent, including Mr. Vijay Agarwal and Ms. Taranum Chema, had opposed the application for early hearing on the ground that it does not serve the public interest. In December 2017, A. Raja, Kanimoji, and 17 others were acquitted by a special CBI judge in both the CBI and ED cases. The special judge had opined that the prosecution had miserably failed to prove the charges against the accused person. Challenging the said order of the special judge, both the ED and the CBI had approached the Delhi High Court in March 2018. Providing respite to the proprietors of the Lakshmi Vilas Palace Hotel, the Rajasthan High Court state arrest warrant issued by a CBI Special Judge Jodhpur in the case. Issuing notice in a plea challenging the special judge order, Justice Dinesh Mehta has restrained the police from arresting Jyotsna Suri. Jyotsna Suri has been directed to present herself in the lower court on October 8th. Furnishing a personal bond of 5 lakh rupees and 2 sureties of 2.5 lakh rupees each. Arrest warrants were earlier issued by the CBI court against Jyotsna Suri, Ashish Goha, Pradeep Bajal and others who have been charged with financial irregularities in the conduct of the hotel's disinvestment. Jyotsna Suri is the wife of the erstwhile proprietors of Bharat Hotels, the group that acquired Lakshmi Vilas from the government after the disinvestment process. Suri's husband was at the helm during the disinvestment. Interestingly, the Central Bureau of Investigation, which was tasked with inquiring into the process, had filed 2 closure reports. Despite this, the CBI special judge rejected the final closure report and directed the arrest of Suri, Gupta, Bajal and others on September 15. And now we are joined by Advocate Shivam Sharma. Shivam, could you please brief us about today's court proceedings?
Yes, in this case, the Rajasthan High Court has observed that court below has not recorded any findings as to why petitioner custodial interrogation is required. So, particularly when all the relevant documents are on the record of the court below, and the transaction dates back to the year 2001, when she was not at the helm of affairs of the company. Further, the court said that if the order of appointment of receiver is not stayed, the hotel in question will suffer irreparable loss. The court has therefore asked the receiver to hand the property back to the authorized representative of the company. Therefore, the bench has restrained the police from arresting Jyotsna Suri, who is the proprietor of the Lakshmi Vilas Palace Hotel. Yes.
Thank you, Shivam, for the update. Moving on. The Jodhpur bench of the Rajasthan High Court has wrapped the CBI court for issuing arrest warrant against former Union Minister Arun Shourie and 4 others in connection with the disinvestment of Lakshmi Vilas Palace Hotel of Udaipur. A single bench of Justice Dinesh Mehta observed, while issuing an arrest warrant, court below has not recorded any finding as to why petitioner's custodial interrogation is required, particularly when all the relevant documents are on the record of the court below and the transaction dates back to the year 2001, when she was not at the helm of the affairs of the company. It may be noted that apprehending the possibility of arrest following the order of the special CBI court, Jyotsna Suri, the managing director of the Bharat Hotels Limited, filed a plea in the High Court. By the bench of Justice Dinesh Mehta, it was submitted by the counsel for the petitioner in the High Court that without even putting her on notice or issuance of summons by the special court, the issuance of an arrest warrant directly was bad in the eyes of law. Senior counsel P.P. Chaudhary and Harish Salve were representing Jyotsna Suri before the court. It was argued before the court that the CBI itself has submitted before the court that since there was no evidence of illegality, the case against the accused should be closed. In these circumstances, it was contended the special court was not justified to reject the closure report filed by CBI without any sound basis. Apart from this, the bench also ordered that the possession of the property be given back to the private company that ran it. The court also ordered that the petitioner shall not be arrested. The Telangana High Court has observed that the preventive detention law cannot be invoked as an easy way method bypassing the ordinary law, and if the detention order is passed, it is very much necessary for the detaining authority to apply its mind and arrive at a conclusion that ordinary law is not capable of acting deterrent against the detainee. And thus detention order needs to be passed. The division bench of the Chief Justice Raghvendra Singh Chauhan and Justice B. Vijay Sen Reddy further observed that the state cannot take advantage of its own lapses, whereby on one hand the state does not effectively oppose the bill application or seek cancellation of bail. On the other hand, state finds an easy way method to pass detention order by invoking preventive detention law. The detention order was passed against Mohammad Nawaz Babulal by the second respondent, Commissioner of Police Hyderabad, in the exercise of powers conferred under subsection 2 of section 3 of the Telangana Prevention of Dangerous Activities of Bootlegger Act, among other acts. This was challenged in this writ of habeas corpus as being illegal and arbitrary. Further, the detaining authority and consider 5 cases as ground for his detention. The government pleader for whom submitted that the detainee is involved in a series of theft cases. The court was of the view that the impugned detention order is vacated also for the reason that under the above 5 crimes related to specific individuals, victims, and come within the ambit of maintenance of law and order and not public order. In the light of the above discussion, the impugned detention order was set aside. The Punjab and Haryana High Court has directed the state government to inform of the number of persons not presently holding public office who had been provided security cover by the state. The direction was issued while hearing a plea moved by former member of the Punjab Legislative Assembly, Bir Devendra Singh. Singh had challenged the state government decision to withdraw his security cover, questioning the state's declared policy of not providing security cover to former MLAs. The petitioner presented a rejoinder with details of certain other former MLAs who continue to enjoy security cover, accepting a sealed cover report from the council for the state containing a status report. Justice Jayashree Thakur allowed the state to file a counter to the petitioner's rejoinder. While doing so, Justice Thakur also directed the state to present a list of persons not holding a public office for whom the state was providing a security over. The order reads, let this court also be informed about the number of persons who have been provided security beyond the state security policy 2013, along with list of those persons who have been allowed security but are not holding any public office other than any security provided to judicial officers. The matter is expected to be taken up next on September 27 this year. And the Allahabad High Court has granted 4 weeks' time to the state government to file its reply in the regular bail plea moved by freelance journalist Prashant Kanodia in connection to a FIR lodged against him allegedly for making social media posts that have the potential to promote enmity between 2 or more communities or groups. Kanodia was arrested by the UP police last month. He had moved the High Court after the Lucknow District Court denied him any relief. As per the facts averred in the District Court's order, the FIR against him was lodged by one Shashank Shekhar Singh under Section 505 1B statements conducing to public mischief and with intent to cause fear or alarm to the public, 501 printing or engraving matter known to be defamatory, and 500 defamation of IPC and Section 67 of the Information Technology Act. It is alleged that Kanodia had posted pictures of the President of India, the Prime Minister of India, and the UP CM Yogi Adityanath on his Twitter account, accompanied by objectionable comments. It was further alleged that he also made comments against the Dalit community, and his posts were intended to incite caste and religious sentiments among the citizens of the country for inciting violence. The complaint had also pointed that Kanodia had criminal antecedent and had been arrested on previous occasions as well. And calling it a concern of seminal importance, the Bombay High Court has issued notice to the state and sought a reply within 2 weeks. In the PIL seeking direction for formulation of guidelines for protection of medical professionals and medical institutions from violence and attacks in case of medical accident, etc. Division Bench of Chief Justice Dipankar Datta and Justice G.S. Kulkarni was hearing a criminal PIL which alleges non-implementation of the Maharashtra Medicare Service Persons and Medicare Service Institution Prevention of Violence and Damage or Loss to Property Act 2010. PIL also condemns that provision of the said act are inadequate to curb the mania of violence against medical professionals and institutions. Therefore, he seeks guidelines to be framed and directions to be issued to the state to implement guidelines in order to protect medical professionals and institutions from mob violence at the behest of the friends and relatives of the patients. Insufficient protection of Medicare service institution and Medicare service personnel is a serious violation of their right to practice medical professions without any hindrance and also their right to life. Petitioner argues that the petition states, unfortunately, the violence against medical professionals is a global phenomenon. According to the World Health Organization, about 38% of healthcare workers suffer physical violence at some point in their careers. However, it is more acute in our country. Apart from direction from formulation of guidelines, the petitioner has also suggested constitution of the committee of experts to look into the definition of medical accidents and possibility of covering medical accidents with suitable insurance. The Karnataka High Court has issued notice on a public interest litigation filed by Advocate Association Bangalore, challenging the scheme framed by Karnataka State Bar Council for distribution of the state grant of 5 crore rupees to the needy advocate as being unreasonable and unfair. The association has sought to quash and set aside the scheme framed on August 26 by the State Bar Council, stating that discriminatory conditions were imposed for the lawyers seeking financial assistance. Under the said scheme, lady advocates, lawyers above 40 years of age, and those enrolled after 1st January 2010 are not eligible for seeking financial assistance. The plea also seeks for direction to the state government to consider the representation made by the association on May 12 and June 22nd, seeking to release a sum of 100 crore rupees as a package to help the lawyers community in the state. Further, it seeks to quash the order passed by the government on August 20. The plea filed through Advocate Anil Kumar states that the state government has, without reasoning and without applying its mind, hastily disposed of the representation without considering the plight of lawyers. The State Bar Council has defended its scheme before the court by saying that on earlier occasion the scheme was framed for advocates who were enrolled subsequently to 1st of January this year. The Karnataka High Court has asked the central government whether it was utilizing or storing the data of individuals who had voluntarily downloaded the Arogya Setu app. A division bench of Chief Justice Abhay Srinivas Oka and Justice Ashok S. Kinagi posed this question while dealing with a plea challenging the downloading and use of Arogya Setu tracking app for COVID-19. Senior advocate Colin Gonsalves argued that no data can be collected even if the user have voluntarily downloaded the Arogya Setu app. During the hearing, the bench asked anybody who voluntarily downloads Arogya Setu app whether the state government is utilizing the data of the individuals who had downloaded Arogya Setu app. The court further stated since it is an app developed by the government of India, first question is whether data of person is collected and used by the government of India. And if the answer for this question is yes, secondly, for what purpose is the data used and under what authority of law? Counsel for the centre, Advocate M. Kumar, sought some time to file a reply as the matter drew a close. The bench advised the Kumar a simple statement you can make, and that even if people download the Arogya Setu app, their individual data will not be collected and used by the government or by any other government agency. The court then proceeded to grant the centre time till October 3rd to respond on the issue. The matter has been adjourned to October 5th. That's it for Courts Roundup today. Thank you for tuning in. Keep watching APN for more updates from news around the nation.
India Legal presents Courts Roundup.